So good morning to you both. Thank you for being with us. We do have you with us for up to 10 minutes this morning. So if you can begin your oral submission, we appreciate that.
Thank you very much. As you say, I'm Don Brash. I'm one of two spokespeople for the Hobson's Pledge Trust. Hobson's Pledge is an advocacy group with some 140,000 supporters. We're named after Governor Hobson, who of course said in the Maori language, as each chief signed the treaty, we are now one people, and that's what we fundamentally believe. Hobson's Pledge supports this bill. When Parliament passed the Marine and Coastal Area Act back in 2011, it was confidently asserted by both the Prime Minister and the then Minister, Chris Finlayson, that there would be successful claims by iwi for customary marine title around the coastline, but they would be rare because they would need to display continuous and exclusive use of that piece of coastline since 1840. The courts have clearly reinterpreted the meaning of exclusive. They've added a concept called shared exclusivity, which makes a total mockery of what Parliament intended. So we feel strongly supportive of this bill as it intends to amend the original Marine and Coastal Area Act. Having said that, if we had a choice, we'd go back to the Foreshore and Seabed Act in 2004, where the Crown owns the foreshore and seabed on behalf of all New Zealanders. But that isn't on the table. So we support this bill. And Brigette will add some comments about some specific details which we think would improve the bill.
Thanks, Don. So I'm Brigette Morton from Franks Ogilvy. We act for Hobson's Pledge, but we also act for the Landowners Coalition, who is an interested party in the Edwards matter, which comes up before the Supreme Court next week. They are submitting separately, so I'm not going to speak directly to their views on the bill, but being informed by our participation in MACA hearings over the last 5 years in particular, we produced a legal opinion for Hobson's Pledge, just drawing attention to some aspects of the bill that we think could frustrate the purpose of the bill. I want to leave as much time for questions as possible, but I wanted to particularly draw the committee's attention to this opinion. It is its supplementary one of the submission, and particularly to paragraphs 33 to 51. This is where we talk about the role of tikanga. In brief, there's a two-stage test that has been established for customary marine title. Tikanga is explicitly taken into account in the first limb, and the courts in the Edwards proceedings has read in the second limb. The minister has been very explicit that they wish to take the test back to what is originally Parliament's explicit wording. Unfortunately, we do not think the mechanism in which this bill does that, which is the new subsection 1 capital A, where it removes any consideration of spiritual or cultural considerations, will do so, and just draw the committee's attention, as I say, to the role of tikanga and how courts have treated tikanga as something beyond a spiritual or cultural norm within our law. But happy to take any questions.
Thank you, Brigette. Dr. Brash. So members, just so we can get the process right. About that, it's just double checking. If you have a question, please indicate by using the raise hand icon, and then I can pick that up on the slide that's there. So first question is from Dr. Duncan Webb.
Kia ora, Mr. Chair, thank you for that, and interested to hear those submissions. I'm just a little interested in your views around customary rights. I think I've got probably two questions if I've got time. One is kind of more philosophical. Given that a customary right, if established, is simply recognising a property right which has existed from 1840 on, what is the kind of underpinning for suggesting that that property right should be expropriated without compensation with a return to the original Act?
Brigette, you going to answer that?
I think I'm not sure if you're referring to this particular amendment bill that seeks to take away any customary marine title that has been already, in some parts, been already awarded? Or are you talking about if there was a return to the Foreshore and Seabed Act?
Well, the Foreshore and I'm really referring to the Foreshore and Seabed Act, but it's fair to say that even if this amendment was passed, there are people who have litigation in train who would have rights deprived from them, which have essentially crystallised, which would pretty much fit the definition of expropriation. And I'm just really perplexed, given Hobson's pledge reputation for being an upholder of property rights, that you'd want to see them removed.
I don't think there's any suggestion that we want to reverse existing decisions of the court. My understanding is that those will stand. What we're saying is where the court has not made a decision, the courts should be guided by what Parliament intended. And right now, they're not being guided by that intention.
Well, that's not exactly how the legislation works, and it's clearly been recognised as retrospective. But let me go to my next question, and I'm just curious about your stance on concurrent exclusive rights, because it's pretty well established, and in fact, English law has long recognised the ability to have concurrent rights into a single piece of property, whether that be a right to hunt deer for one person and cut wood for another, which is, the old law of the forest, or simply land law, where you can have licenses in respect of the same land to do different activities on it, mine it and farm it. So I'm really perplexed as to why you say concurrent rights in respect of marine areas are foreign to the law when clearly it's well recognised.
So I will take that question. I think there's a difference between different use rights in terms of property rights and shared exclusivity. So in this context, we're looking at multiple iwi or hapu having the same rights, say collection of seafood or fishing rights, or the ability to place rahui on a particular coastline. So they're not independent of each other. They can be the same right over the same area.
Can I just clarify then, if one iwi had a right to collect shellfish and the other had a right of passage with their waka, would you accept that we should have a piece of legislation which recognises those as customary rights which can coexist?
So they would still need to meet the test under the law, which they need to show uninterrupted exclusive use throughout. So therefore, if the, say, ability to launch waka and the ability to collect kai moana were able to operate without having interrupted each other's use, then that would indicate that that is allowable under the MACA.
All right. Okay, thank you. We'll let someone else ask a question.
A question from Tākuta.
Tēnā koe te chair. Tēnā koe Tākuta Brash. Korua koto hoa. I have a raft of questions, but I'll just ask you a couple here. With regard to your framing and approach to the marine and coastal areas bill, do you think that, or do you deem customary title, which Māori have been allowed to pursue within the parameters of the law, equates to ownership or some form of ownership?
Well, it's clearly a kind of ownership. It enables the group which has that right to exclude others under certain circumstances. So it clearly is a form of ownership.
Oh, kia ora. So it's a form of ownership. Māori have long utilised their own coasts in conjunction with neighbouring iwi and iwi that they may have had a relationship with who lived way in the mountains. At the arrival of early Europeans, Māori continued to share the use of their coasts with those new people. In 2004, all of the rights that Māori possessed relative to the coasts that they occupied were confiscated. and a test was established, the exclusivity test. Now, I would I would implore you to consider that Māori have the right to share their coasts with whoever they deem suitable, while still maintaining their mana over that same coast. So that's a Māori point of view that I would really like to hear what you have to say about it.
I think if you look at the experience of the Maki hearings to date and the applicants' evidence that they have put forward, that there may be some circumstances in which that has occurred where there has been agreement, and that would not, I don't believe, necessarily mean that there's been substantial interruption where there's been agreement of use. But you see through the competing of applications that actually there's many iwi and hapu that have not agreed use and actually have declared separate applications and separate evidence as to their own exclusive use.
Do you, just quickly then, I don't want to take up all the time, just quickly, do you think that that declaration of exclusive use has come about as a case of Pākehā law?
So we are operating
in response to, sorry. So iwi and hapu who have put in exclusive claims excluding a neighboring hapu or iwi, do you think that that's a symptom of having to deal through Pākehā law?
So as a lawyer, I operate under what the law set by the New Zealand Parliament. I don't define the difference between Pākehā and non-Pākehā law.
So thank you to Dr. Brash and Brigette from Hobson's Speech for your submission.